If you own a firearm in 2026, believing the wrong information could cost you your freedom. I'm talking fines, felony charges, or worse, losing your Second Amendment rights permanently. Right now, there are 5 gun law myths spreading like wildfire online, and thousands of gun owners just like you are falling for them. Some of these myths came from so-called experts, and they're dead wrong. But here's the good news. I'm going to fact-check every single one of these myths using the actual 2026 federal and state laws, so you know exactly where you stand legally. No opinions, no politics, just the facts that could keep you out of serious trouble. Let's get into it. Myth number 1 is one of the most dangerous ones I see repeated constantly online and at gun shows. You've probably heard someone say this: you don't need a background check when you buy from a private seller. Here's why this myth can land you in federal prison. While it's true that federal law doesn't require background checks for all private sales, that's where people get it twisted. Because here's what they're not telling you. First, as of 2024, the ATF expanded the definition of who qualifies as a firearms dealer. If you're engaged in the business of selling firearms, even occasionally for profit, you must have an FFL license and conduct background checks. The days of the so-called hobby seller loophole are gone. So if you're flipping guns at gun shows or selling regularly online, the ATF considers you a dealer, and you better have that license. Second, 11 states now require background checks for all firearm sales, including private transactions. I'm talking about California, Colorado, Connecticut, Delaware, Nevada, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, and Washington. If you live in any of these states and you sell a gun to your buddy without going through an FFL for a background check, you're breaking the law. Period. Third, and this is the big one, even in states without universal background check laws, if you knowingly sell to a prohibited person, a felon, a domestic abuser, or someone with a restraining order, you are committing a federal crime. And guess what? Saying, "I didn't know," is not a legal defense if prosecutors can prove you should have known. Let me give you a real example. In 2023, a Texas man sold 3 handguns through Facebook Marketplace without background checks. He thought he was just making some extra cash. One of those guns was used in an armed robbery 2 weeks later. The ATF traced it back to him, and that seller is now serving 5 years in federal prison for dealing without a license and transferring firearms to a prohibited person. 5 years. Gone. Because he believed this myth. If you're selling firearms privately in 2026, here's what you must do. Number 1, know your state laws. Universal background checks may be required where you live. Number 2, if you're selling more than occasionally, get an FFL. Don't mess around with this. Number 3, use an FFL transfer service to protect yourself legally. It costs maybe $30 to $50, but it could save you from 5 years in prison. And number 4, never sell to someone you don't know without verification. Don't risk your freedom for a few $100s. The ATF is watching online marketplaces, gun shows, and private sales more closely than ever before. They have agents monitoring arms list, Facebook groups, and local classifieds. They're setting up sting operations at gun shows. This isn't paranoia. This is reality in 2026. Alright, myth number 2 is spreading like crazy in 2026, especially with 29 states now having constitutional carry laws. People are saying, constitutional carry means I can carry my firearm anywhere without restrictions. This one's getting people arrested every single week. Let me break down the truth. Constitutional carry, also called permitless carry, does not mean unrestricted carry. Not even close. What it means is that you don't need a permit to carry a concealed firearm in your state. But there are still massive restrictions on where you can carry. Even in constitutional carry states, federal law prohibits firearms in specific locations. We're talking about federal buildings like courthouses, post offices, and social security offices, federal parks, and wildlife refuges, with very few exceptions. All military bases, no matter what state you're in. Secure areas of airports beyond the TSA checkpoint, and Indian reservations, because they set their own rules independent of state law. But here's where it gets really tricky and where people are getting arrested. Every single constitutional carry state still has its own list of prohibited locations. These commonly include schools and school zones. The Gun-Free School Zones Act is federal law, and it's still fully enforced. You cannot have a firearm within 1,000 feet of a school in most circumstances. College campuses, and the rules vary wildly by state. Some allow campus carry, others don't. Bars and establishments that serve alcohol, you're usually prohibited from carrying there. Government buildings at the state and local level. Polling places during elections. Hospitals and medical facilities in many states. Sports arenas and stadiums. And here's one people forget: private property with posted no firearms signs. In many states, ignoring those signs is a criminal offense, not just trespassing. Here's a real story from 2025 that should terrify you. A Florida man with absolutely no criminal record was picking up his grandson from school. He had his legally owned concealed firearm in his vehicle, which was legal. He parked in the school parking lot, walked into the school office to sign out his grandson. The school resource officer noticed the outline of his gun printing through his shirt. He was arrested on the spot for carrying a firearm in a school zone, a federal felony with a mandatory 5-year minimum sentence. No judicial discretion. 5 years minimum. His defense in court? Florida is a constitutional carry state. I have the right to carry. The judge's response: federal law supersedes state law. You're guilty. That man, a grandfather with no record, is now serving time in federal prison because he believed constitutional carry meant he could carry anywhere. And here's something most people don't know. Even if your state has constitutional carry, traveling to other states becomes an absolute legal minefield. Constitutional carry does not mean other states recognize your right to carry. You need to check reciprocity agreements state by state. And here's the kicker: some states only recognize permits, not constitutional carry. So even though you can legally carry in your home state without a permit, the neighboring state might require you to have an actual permit for them to recognize your right to carry there. For example, if you're from Texas, which is a constitutional carry state, and you drive through Louisiana, which is also constitutional carry, you're fine. But the moment you cross into New Mexico, you're breaking the law unless you have a recognized permit. New Mexico doesn't honor constitutional carry from other states. They want to see an actual permit with reciprocity. I've heard from viewers who got pulled over for a simple traffic stop in another state, told the officer they had a firearm as required by law, and ended up in handcuffs because their state's constitutional carry wasn't recognized. Before you carry anywhere in 2026, you need to do these things. Download a current reciprocity app. I personally recommend CCW Safe or the USCCA app. They update in real time with law changes. Know the federal prohibited locations by heart. I mean, memorize them. Research your destination state's specific restrictions before you travel. Every single time. If you travel regularly across state lines, consider getting a multi-state permit for maximum reciprocity. Many states offer non-resident permits specifically for this reason. And finally, never assume. Verify every single time. One mistake, one wrong turn into a school zone. One stop at a post office with your concealed carry can turn you from a law-abiding citizen into a felon in seconds. Don't let constitutional carry give you a false sense of security. Myth number 3 is costing law-abiding gun owners thousands of dollars in missed opportunities for hearing protection. Here's what people believe. Suppressors, also called silencers, are illegal to own. This myth comes straight out of Hollywood, and it's completely false. Suppressors are 100% legal to own in 42 states as of 2026. Let me say that again for the people in the back. 42 states allow civilian ownership of suppressors. That's the vast majority of the country. The only states where suppressors remain illegal are California, Delaware, Hawaii, Illinois, Massachusetts, New Jersey, New York, and Rhode Island. 8 states. That's it. So if you live outside these 8 states, you absolutely can legally own a suppressor. But here's the catch, and this is important. Suppressors are regulated under the National Firearms Act of 1934, also called the NFA. This means you can't just walk into a gun store and buy one like you would a regular firearm. You need to go through a specific legal process, and messing this up can land you in federal prison. Here's how it works. Step 1. You need to find a Class 3 dealer in your area. That's also called an SOT dealer, Special Occupational Taxpayer. These are dealers specifically licensed to handle NFA items like suppressors, short-barreled rifles, and machine guns. Step 2. You select your suppressor and complete ATF Form 4. This is the application for tax-paid transfer of a firearm. You're not buying the suppressor yet. You're applying for permission to own it. Step 3. You submit your fingerprints, a passport photo, and a $200 tax stamp to the ATF. That $200 is a federal tax, and it's non-refundable even if you're denied. Step 4. You wait for ATF approval. As of 2026, the wait time is averaging 6 to 9 months. I know that sounds insane, but that's the reality. The ATF is backlogged. Step 5. Once approved, you pick up your suppressor from the dealer. Not before. This is critical. Here's where people get into massive trouble. During that waiting period, you do not own the suppressor yet. The dealer holds it in their inventory. If you take possession of that suppressor before ATF approval comes through, even if you've paid for it, even if you're just taking it to the range to test it, that is a federal felony. We're talking 10 years in prison and a $250,000 fine. I'm not exaggerating. People have gone to prison for this exact mistake. So why does this myth persist? Why do so many people think suppressors are illegal? Hollywood has convinced the American public that suppressors make guns whisper quiet and are only used by assassins and hitmen. Every action movie shows a suppressed pistol making a little sound and nobody hearing it. That is complete fiction. The reality? Suppressors reduce noise to hearing-safe levels. They don't silence a gun. A suppressed 9mm pistol is still around 125 to 130 decibels. That's as loud as a jackhammer. It's loud. You're still going to hear it from hundreds of yards away. What it does is bring the noise down below the threshold for instant hearing damage, which is 140 decibels. An unsuppressed 9mm is 160 decibels. That causes instant, permanent hearing damage. A suppressed 9mm is 125 to 130. That's hearing safe, but it's still very loud. It's not silent. It's not whisper quiet. It's just not going to destroy your hearing. In fact, and this blows people's minds, in many European countries, suppressors are required by law for hunting. They're considered basic hearing protection and a courtesy to reduce noise pollution for neighbors. In Finland, Norway, and France, you can buy suppressors over the counter with less paperwork than buying the gun itself. Now, here's some good news for 2026. The Hearing Protection Act has been reintroduced in Congress. This bill would remove suppressors from NFA regulation entirely. You'd be able to buy them like any other firearm accessory with just a standard background check. No tax stamp, no 9-month wait. While it hasn't passed yet, there's growing bipartisan support. Gun rights advocates want it for obvious reasons, but even some Democrats are supporting it because it's fundamentally about hearing conservation. If you want to protect your hearing in 2026, here's what you need to do. First, verify your state allows suppressor ownership. Check your state laws. Second, find a reputable Class 3 dealer in your area. Ask other gun owners for recommendations. Third, budget for the cost. You're looking at $200 for the tax stamp plus the cost of the suppressor itself, which ranges from $400 to $1,500 depending on quality and caliber. Fourth, be patient with the approval process. 6 to 9 months is a long time, but it's worth it. Fifth, and I cannot stress this enough, never take possession before approval. Don't even touch it. And sixth, once approved, you can use that suppressor on any firearm in the appropriate caliber. One suppressor can work on multiple guns. Suppressors are legal, they're practical, and they're one of the best investments you can make for hearing protection. If you shoot regularly, especially indoors, you're doing permanent damage to your hearing every single time. Don't let Hollywood myths stop you from protecting your ears. Myth number 4 has exploded in popularity over the last few years, especially with the rise of online kits and 3D printing. People are saying you can build a ghost gun without any legal issues. It's completely legal and untraceable. This myth is getting people raided by the ATF and charged with federal crimes. Let me explain what's actually legal and what will land you in prison. First, let's define what we're talking about. A so-called ghost gun is a privately made firearm, often built from an 80% lower receiver or 3D printed parts. These firearms typically don't have serial numbers, which is where the term ghost gun comes from. They're harder to trace. Now, here's the truth. Building your own firearm for personal use is legal under federal law. It has been since the founding of this country. If you want to machine your own receiver, 3D print a frame, or finish an 80% lower in your garage, federal law allows that for personal use. You don't need an FFL. You don't need permission from the government. That part is true. But here's where the myth falls apart, and people get into serious trouble. As of August 2022, the ATF issued a new rule that dramatically changed the game for privately made firearms. Under the new rule, if you're building firearms to sell, even occasionally, you need a manufacturer's FFL. And any privately made firearm you complete must have a serial number engraved on it within 7 days of completion. Not optional, required. This means if you're building AR-15s from 80% lowers and selling them at gun shows or online, even just 1 or 2, the ATF considers you a manufacturer and you're required to have a Type 7 FFL. If you don't, you're manufacturing firearms without a license, which is a federal felony. We're talking 10 years per offense. And here's the kicker. The ATF is actively monitoring online marketplaces for privately made firearms. They're on gun forums, Facebook groups, Arms List, Gunbroker. They're looking for people selling unserialized firearms. And when they find you, they're bringing federal charges. Let me tell you about a case from 2024. A California man was building polymer 80 Glock frames in his garage. He wasn't a criminal. He was a hobbyist who liked building guns. He built about 15 of them over 2 years and sold a few to friends and online to cover his costs. He thought he was fine because he was building them for personal use initially. The ATF disagreed. They raided his home, seized all his firearms, all his tools, his computers. He was charged with manufacturing firearms without a license and dealing firearms without a license. He took a plea deal and got 3 years in federal prison plus a lifetime ban on firearm ownership. His life is ruined because he believed this myth, but it gets even more complicated depending on where you live. Several states have banned privately made firearms entirely or added severe restrictions. California now requires all privately made firearms to be registered with the state and have a serial number issued by the DOJ before you even start building. If you complete a firearm without going through this process, it's a felony. New York, New Jersey, Washington, Connecticut, and Hawaii have similar laws. Delaware banned unserialized firearms outright in 2022. And here's something critical about serialization. If you build a firearm for personal use and later decide to sell it, you must serialize it before the sale. You can't transfer an unserialized firearm to another person. That's trafficking in untraceable weapons, and it's a serious federal crime. The ATF has made it very clear. Any transfer of a privately made firearm requires serialization. Now let's talk about 3D printed firearms specifically, because this is where a lot of confusion exists. 3D printing a firearm is legal for personal use under the same rules as any other privately made firearm. You can print a frame or receiver at home. But here's where people are getting jammed up. First, if any part of your 3D printed gun is made from metal and isn't detectable by a metal detector, you're violating the Undetectable Firearms Act of 1988. That's a separate federal crime. Your gun must be detectable. Most 3D printed guns use metal rails and barrels, so they pass this requirement. But if you're printing a fully plastic gun, you're breaking federal law. Second, the files for 3D printed firearms are considered defense-related technical data under IEAR, the International Traffic in Arms Regulations. Sharing these files online, especially to foreign nationals, can be considered illegal arms trafficking. Yes, I know the files are all over the internet, but legally, distributing them can land you in federal prison. The State Department has gone after people for this. Third, and this is new for 2026, some states are attempting to ban 3D printed firearms entirely. New York passed a law making it illegal to possess a 3D printed firearm or even the files to create one. This is being challenged in court, but as of right now, the law is on the books. If you're thinking about building a privately made firearm in 2026, here's what you absolutely must do. Number 1, verify it's legal in your state. Some states have outright bans. Number 2, if you're building for personal use only, you're generally okay under federal law, but you must serialize it if you ever plan to sell or transfer it. Number 3, never build firearms with the intent to sell unless you have a manufacturer's FFL. The ATF will prosecute you. Number 4, ensure your firearm is detectable under the Undetectable Firearms Act. It must set off a metal detector. And number 5, do not distribute 3D printer files online without understanding IEAR regulations. Building your own firearm can be a rewarding hobby, and it's a right that Americans have exercised for centuries. But in 2026, the legal landscape has changed dramatically. The ATF is cracking down hard on so-called ghost guns, and ignorance of these new rules will not protect you in court. Alright, we've reached myth number 5, and this is the most dangerous myth on this entire list because it's getting people killed and it's getting people sent to prison for decades. Here's the myth. Stand your ground laws mean you can shoot anyone who threatens you. If you believe this, you could end up dead or you could end up in prison for murder. Let me explain what stand your ground actually means. Stand your ground laws exist in 38 states as of 2026. What these laws do is remove the duty to retreat before using deadly force in self-defense. In states without stand your ground, if you can safely retreat from a threat, you're legally required to do so before using deadly force. If you don't retreat when you could have, you can be charged with murder even if the other person was threatening you. Stand your ground says you don't have to retreat. If you're in a place you have a legal right to be and you're facing an imminent threat of death or serious bodily harm, you can use deadly force to defend yourself without retreating first. That's it. That's all stand your ground does. But here's what stand your ground does not do, and this is critical. Stand your ground does does not eliminate the requirement that you face an imminent threat. The threat must be immediate. If someone threatens to kill you tomorrow, you can't shoot them today and claim stand your ground. If someone is walking away from you, they're no longer an imminent threat. If someone is yelling at you but not physically attacking you or displaying a weapon, that's not an imminent threat of death or serious bodily harm. Words alone, no matter how threatening, are not enough to justify deadly force. Stand your ground does not eliminate the requirement of proportional response. You can only use deadly force to counter a threat of death or serious bodily harm. If someone shoves you in an argument, you cannot shoot them. If someone punches you once and backs away, you cannot shoot them. The level of force you use must be proportional to the threat you're facing. Stand your ground does not allow you to be the initial aggressor and then claim self-defense. If you start the fight, if you escalate the situation, if you're committing a crime, stand your ground doesn't apply. You can't pick a fight and then shoot the person when they fight back. Let me give you a real example that shows how badly people misunderstand this. In 2023, a Florida man got into an argument with another driver over a parking space at a grocery store. The argument became heated. The other driver got out of his car and approached, yelling and pointing his finger. The armed man felt threatened. He drew his firearm and shot the other driver, killing him. He claimed stand your ground. He said he feared for his life. The jury watched the security camera footage. They saw the victim was unarmed, was not physically touching the shooter, and was standing several feet away when he was shot. The shooter was convicted of manslaughter and sentenced to 20 years in prison. Stand your ground did not protect him because the threat was not imminent. The response was not proportional, and a reasonable person would not have believed deadly force was necessary. Here's what you need to understand. Even in stand your ground states, every single self-defense shooting will be investigated. The police will investigate. The prosecutor will review it. And if they believe you did not meet the legal standard for self-defense, you will be charged. Stand your ground is not a get-out-of-jail-free card. It's not a license to shoot people. It's an affirmative defense you raise in court, and you still have to prove your use of force was justified. And here's something most people don't know. In many stand your ground states, if you're charged with a crime, you can request a stand your ground immunity hearing before trial. This is a hearing where a judge, not a jury, decides if your use of force was justified. If the judge rules in your favor, the charges are dismissed and you can't be prosecuted. But if the judge rules against you, you go to trial and that judge's ruling can be used against you. You need to understand the specific self-defense laws in your state. Stand your ground laws vary significantly. Some states have strong stand your ground protections. Others have weak protections with lots of exceptions. Some states don't have stand your ground at all and maintain a duty to retreat. Before you ever carry a firearm for self-defense, you must do these things. Number 1, take a comprehensive self-defense law class specific to your state. I'm talking about a real class taught by a lawyer, not a 2-hour CCW course. Organizations like USCCA and CCW SAFE offer excellent training. Number 2, understand the legal standard for use of deadly force. You must reasonably believe you face imminent threat of death or serious bodily harm. Number 3, know your state's specific stand your ground provisions, castle doctrine, and duty to retreat laws. Number 4, get self-defense liability insurance. If you're ever involved in a self-defense shooting, even a justified one, you're looking at $50,000 to $200,000 in legal fees. Insurance covers this. And number 5, avoid confrontation whenever possible. The best self-defense situation is the one you never get into. Carrying a firearm is a massive responsibility. It's not just about your rights. It's about understanding when you can legally use deadly force and having the judgment to make that decision correctly in a split second. Because if you get it wrong, you could spend the rest of your life in prison even in a stand-your-ground state. So there you have it, 5 gun law myths that could get you into serious legal trouble in 2026. Let's recap real quick. Myth 1, private sales don't need background checks. Wrong. Know your state laws and the ATF's expanded dealer definition. Myth 2, constitutional carry means you can carry anywhere. Wrong. Federal and state restrictions still apply everywhere. Myth 3, suppressors are illegal. Wrong. They're legal in 42 states with proper NFA paperwork. Myth 4, ghost guns are unregulated. Wrong. New ATF rules require serialization and restrict manufacturing. Myth 5. Stand your ground lets you shoot anyone who threatens you. Wrong. You still must meet strict legal standards for self-defense. Here's the reality. Gun laws in 2026 are more complex than ever. Federal rules are changing. State laws are changing. What was legal 5 years ago might be a felony today. And ignorance of the law is never a defense. If you found this video valuable, do me a favor. Hit that subscribe button and turn on notifications because I'll be covering more critical gun law updates throughout 2026. The laws are changing fast, and I want to make sure you stay on the right side of them. And drop a comment below. Tell me which myth surprised you the most, or let me know if there are other gun law myths you want me to fact check. I read every comment. Remember, the Second Amendment protects your right to keep and bear arms, but it doesn't protect you from criminal charges if you break the law. Stay informed, stay legal, and stay safe. I'll see you in the next one.